Back to Court TV Live. I'm legal correspondent Julia Janae in for Ted Rollins. Our next live trial begins on Monday with jury selection. It's the bar fight murder trial in Tennessee. The defendant, Michael Mosley, you see him there, is accused in a triple stabbing that left 2 college students dead outside of a popular Nashville bar. Here's a look at the key dates in that case. On December 21st, 2019, at 2:52 a.m., police respond to reports of a stabbing at the Dogwood Bar in downtown Nashville. Investigators quickly identify a suspect, Michael Mosley, based on surveillance video and eyewitness statements. Police say the incident began inside the bar with a dispute, possibly over a woman, then spilled outside onto the street. 2 men, Clay Beathard and Paul Trapani, were fatally stabbed. Beathard was a college football standout. His brother CJ plays in the NFL. A third victim, AJ Bethram, survived the attack. After a days-long statewide search, police apprehend Mosley in a vacant house on Christmas Day. On June 4th, 2020, a grand jury indicts Michael Mosley on 2 counts of first-degree murder, as well as attempted first-degree murder and assault. Mosley is claiming self-defense. If convicted, he faces life in prison. A preliminary hearing was held in this case back in 2020. The court heard from 3 different witnesses, including the only victim to survive the stabbing. Our affiliate in Nashville, WTVF News Channel 5, filed this report about what has been revealed at that hearing back in 2020.
It all started here on December 21st in the Dogwood Bar. A witness testified that suspect Michael Mosley was seen talking to a girl, and her boyfriend Sam confronted him. Then Mosley punched him.
I walked back up the steps and grabbed Mosley and told him that that's not what we came here to do.
Mosley's friend, Miss Harper, testified she broke up the fight and Sam left with the group of Battleground Academy graduates. Assistant District Attorney Jan Norman says Mosley had time while leaving the bar to think about what he was going to do.
But it was someone in Mr. Mosley's group that said, we're going to fight, and Mr. Mosley started this fight that ended in 2 people being murdered. And 1 person, AJ, escaping with his life.
As the bar closed, everyone headed outside. That's when the brawl started, and it was caught on surveillance camera. Mosley's defense attorney, Justin Johnson, says when the video is made public, it will tell the full story of what transpired.
And I believe it will show Mr. Mosley starting to walk away, being confronted by the person that I had stated. It appears to be quite visible on the video what happened, and that at that point, a fight did break out.
During the brawl, police say Mosley stabbed Paul Trapani III and Clay Beathard to death. AJ Bethram testified that he saw a female friend get pushed to the ground, so he punched someone and then was stabbed in the eye and arm.
When I got hit, my vision went black.
After the hearing, Michael Mosley's mom stopped to speak with us. She tells us that her son cried when he found out that 2 people died that day.
She believes he acted in self-defense, but the prosecutor says there's no excuse for Mosley's actions.
I do. I really do. Like I told him when they were looking for my son, if he didn't think his life was in danger, this would not have happened.
Let's bring in our amazing guests. Sue Ann Robinson, a criminal defense attorney and former prosecutor in Fort Lauderdale, Florida, and trial attorney Ken Gurney in New York. I want to focus on that statement that the prosecutor said during the preliminary hearing, that it was someone in Mosley's group who said, we are going to fight. And then you have these 2 factions going at it in front of a bar. Sue Ann, how do you piece through that as a prosecutor when it wasn't Mosley who said, we're going to fight when this fight broke out?
And you know, that's the thing, Janae. It's hard to decipher based on what we've seen so far of the video, who the primary aggressor is. Yes, someone in Mosley's group said we're going to fight, and that gives us more of a context, but it's so difficult to find out what we need to know for a self-defense claim, which is what is Mosley's state of mind? What is he thinking? Is he now thinking, okay, I need to fight. I'm in danger. I'm in danger of great bodily injury. And that's really what the jury is going to be responsible for looking for, what Mosley's state of mind was and whether or not his actions based on what he was approached with and what his context was, whether his actions were reasonable.
Canon Suan is saying state of mind, state of mind. I want to ask you about what happened after this fight, this stabbing where two people were found dead and police rushed to the scene. There's chaos, I'm sure. They couldn't find the defendant. It took them days to find him. He was in an empty house miles away from where this happened, and he was taken into custody. The Tennessee Bureau of Investigation had to get involved. Is that flight something that this jury may have an issue with if he's claiming, I was standing my ground, I was defending myself?
Well, that is a great thing to look at, is his flight. He did run, but we have to look at the defendant as someone who's not an attorney, not a judge, not an individual who really understands the criminal system. He probably was very scared. He knew that he stabbed someone. I don't think that anyone's not saying that he didn't actually use a knife at the day of incident. However, he doesn't want to be seen as someone who's a murderer if he's a person who was defending himself. If his state of mind was someone who felt that his body would be seriously endangered or his life would be taken away. So yes, the jury may look to the fact that he ran, that may look to the fact that the police actually had to apprehend him. But I do believe that in the end, it will not have as big of a weight on what actually occurred.
Sounds like exactly how the defense attorney will likely try to diffuse that in front of the jury. But they've got another hurdle that they've got to get over. If it comes in, we don't know. Even in looking at the motions in limine at pretrial, it's not clear if some of those prior bad acts may come in, the ones that resulted in convictions. One of those, a fight in a Walmart. I think we have video of that surveillance where he was convicted of attacking a woman who was shopping. He did know her. He had some motive because she was accused in the murder of his brother, but it's a violent attack. He's dragging her. He kind of goes at her with what's believed to be a key in his hand, so not a knife, not the same kind of incident, but it really shows what he could be capable of if you're the prosecution. And there was also a fight in a jail where the details are pretty sick. He had a bottle, a shampoo bottle that he then used on a jail employee that was full of urine, but these could come in, can they? Suan, what do you think?
When you're using self-defense, you open yourself up to the chance that the prosecution is going to be able to show that you have a propensity for violence. So I think that's why these videos and these prior incidents of him fighting can come in to demonstrate, hey, this isn't some frail guy that's really concerned. He gets in fights all the time and he likes fighting, and this is the type of thing that he does. But you know what? I think that's why it's going to be so heavily litigated, because it's going to come down to, it's going to be such a fact-intensive finding for the court to go through and say, okay, is this going to be super prejudicial and cause this case to come back on appeal? Or is this a case where his prior incidents of being in fights can really aid the jury in this case?
These are all great points. This is a case that we are going to be covering starting on Monday. You don't want to miss